So guys, welcome to another episode of Scott Talks. This is an episode whereby Scott talks law, and in this episode we are going to look at the defenses in torts. So we have the general defenses and the specific defenses. The general defenses are those defenses that apply in almost all types of torts, while the specific defenses are those defenses that apply to specific torts. Examples of specific defenses: defense of consent, voluntary and fit injuria; defense of contributory negligence; the defense of necessity; defense of statutory authority; defense of inevitable accident; the defense of act of God or force majeure; the defense of act of the third party or the stranger; and the defense of mistake. Let's start with the defense of voluntary and fit injuria. So this voluntary and fit injuria, this is the defense of assumption of risk. This is whereby the plaintiff knows the risk, yet he proceeds and takes the risk. This defense applies in two ways. First, there must be consent. The plaintiff must know the risk and must have the knowledge of the nature of the risk. And the second, the plaintiff must agree or incur the risk voluntarily. You know the risk, then you incur the risk. That is the concept. And in the case of Hall versus Brookland Auto Racing Club, the spectator the motorcar race which was held at Brooklands on a track hall, the defendant So there's a collision between two cars, one of which was thrown amongst the spectators, thereby injuring the plaintiff. The plaintiff sued the defendant, and the issue was whether the defendant there was the defense of consent or voluntary and fit injuria. The court held that the plaintiff impliedly took the risk of such injury, the danger being inherent and by any spectator who could foresee such danger. Hence, the consent was implied and the defendant was not liable. So the plaintiff had consented. While him going to attend that racing, he had consented or assumed to the risk. So he could not issue any. So the defense of voluntary and fit injuria applied because the spectator could not have foreseen such danger. Hence, the consent was applied. So the defendant was not liable. So this is a case whereby the plaintiff has gone to attend a racing. So there is a collision between two vehicles. One vehicle has injured the plaintiff because of the collision, because it was thrown to where the spectators were. So the plaintiff is where the spectators are, and the plaintiff is injured as a result of the collision. So the defense side has raised the defense of voluntary and fit injuria. So the court held that this defense of voluntary and fit injuria applies because the plaintiff had consented when he attended the rally, so he could not be awarded. So this voluntary and fit injuria applied. So in the case of R versus William, is also another case of this defense, and this is whereby a music teacher was held guilty of rape, and he claimed that he raped because it could aid the girl in improving her voice, but the court could not allow, so the court held that the consent here was not genuine because it was obtained by fraud, because the 16-year-old girl did not understand the real nature of the act done, and so the consent was not considered as a vitiating factor. So mere knowledge does not amount to consent. For the maximum of voluntary and fit injuria to apply, the 2 points must be asserted. The plaintiff had the knowledge of that risk, and despite of the knowledge, he agreed to take the risk. Negligence of the defendant. For the defense to be viable for the defendant, it is necessary that the act done must be the which the consent has been given. So yes, indeed the consent was there, but the defendant had been negligent or acted in a negligent way, then he cannot raise this defense of volunteering and fetching duty even if the plaintiff had consented. You are not supposed to act in a negligent way. For example, if a patient has consented for a surgery by the doctor and then a doctor acts in a negligent way, then he kills the patient, the doctor cannot raise this defense of volunteering and fetching because of the consent of the plaintiff, or the plaintiff assuming to take the risk because he was negligent. So negligence cannot apply or cannot apply under this defense of volunteering and fetching. If you are negligent as a defendant, you cannot raise a defense of volunteering and fetching. So the consent of there are factors which vitiate consent. The first factor is the factor of misrepresentation. The second factor is the factor of mistake of facts, and the third factor is the factor is that one of duress. So these are factors that vitiate this defense of volunteering and fetching duty. So another defense is the defense of contributory negligence, and this defense requires that the plaintiff must take reasonable action to avoid that danger. He is not supposed to have that liability, but he must just take reasonable actions to escape that danger if he or she is in danger. So the fault doesn't mean that the plaintiff owes the duty of care to the defendant, but it means that plaintiff had failed to take care of his or her own safety. So you must just take care of your own safety, even if the defendant is liable. So this is the defense of contributory negligence. That defense is the defense of statutory authority, whereby the statute might prevent someone from being liable for committing a particular crime. When a statute or authority when a statute authorizes a certain act to be due by the person who would otherwise be unlawful, no action will lie against such person. So if you are permitted by a statute, even if you did an illegal act, that act cannot be punishable. You cannot be punished for your actions, for your illegal actions, because of the statute or the statutory authority. The fourth defense is the defense of mistake, and as the general rule, the mistake of facts but not the law. So mistake of law is not a defense, it must be the mistake of facts. So the fifth defense is the defense of inevitable accident. So an accident may be regarded as inevitable if it was not intended by the defendant and could not have been avoided in exercising of reasonable care. So if an accident was not able to be avoided, then the defendant can raise this defense of inevitable accident, that accident which could not be avoided by any ordinary means. So the defendant tried to avoid that accident, but he could not avoid that accident. So you can raise this defense of inevitable accident if you are a defendant. So the sixth defense is the defense of act of God, where the accident was as a result of the forces of nature or the causes of nature. So no human intervention could prevent that accident. So for this defense to succeed, the act must be unforeseeable, and it must be as a result of natural or unusual cause. The seventh defense is the defense of necessity, and this may be pleaded if the tort complaint of was necessary to protect the society. And this defense is mostly raised by government bodies or agencies. When government bodies want to implement some particular issues want to acquire a particular land under the doctrines of compulsory acquisitions or the police power, if their intention is to protect their society, then they can raise this defense of necessity. If the purposes of the defense, if it was to profit the general society, then they can raise it as a defense. So those are the defenses in tort. There are also other many defenses, but I think we'll just get time to talk about all of them in another episode, not in this episode. But just keep on staying in touch because I will talk about them.